If you are somewhere in the middle of the US immigration process right now, waiting on a green card, a work permit, a visa interview, or any kind of application, this video is going to matter to you. Because in 2026, the immigration system is moving differently than it has in years. Processing times are longer, screening is deeper, the requirements have shifted, and the people who are getting caught off guard are not people who did anything wrong. They are people who simply did not know what changed. So let's go through it clearly, category by category, so you know exactly where you stand and what you need to do about it. Let's start with something that affects everyone in the immigration pipeline right now, regardless of country or visa type. And that is the simple question of how long things are taking. As of early 2026, USCIS processing times across most major immigration categories are longer than the published estimates, and immigration attorneys across the country are flagging this consistently. Family-based I-130 petitions, the form used to sponsor a relative for a green card, are taking up to 35 months in some categories. The I-485, which is the application to register permanent residence or adjust your status to a green card, is currently taking anywhere between 6 months and 41 months depending on your category and which service center is handling your case. Green card renewals through Form I-90 are running over 8 months, and work permit renewals through Form I-765 are stretching longer than many applicants were expecting when they first filed. These are not estimates from unofficial sources. USCIS publishes its own processing time tool at uscis.gov, and immigration attorneys are urging applicants to check their specific form, category, and service center, because the numbers vary significantly depending on all three of those factors. What the estimates do not tell you is the full story of what is happening underneath the surface in 2026, which is a much more significant shift in how USCIS is actually doing its job. Here is the core change that is driving most of the delays you are hearing about in 2026. The U.S. immigration system has moved into what officials are describing as a security-first posture. That means more background checks, more identity verification, more scrutiny of travel history, and more discretionary review for cases that would previously have moved through the system with minimal additional examination. This is not happening quietly. In late March 2026, USCIS published an official public update on its website explicitly acknowledging expanded screening and vetting procedures, and explaining that it had concluded through internal review that prior vetting measures were insufficient. What does that mean in practical terms? It means that the same application you would have filed 2 years ago, same documents, same eligibility, same clean history, now has more steps between submission and approval, more background checks that need to come back clear, more coordination between USCIS, the State Department, and other agencies before a final decision can be made. And for many applicants, that translates directly into waiting longer than they planned. Now let's talk about which applicants are experiencing the most significant impact, starting with those from countries under enhanced scrutiny. At the start of 2026, travel restrictions that were introduced in 2025 were expanded. The U.S. government now designates certain countries as high risk based on assessments of their identity document systems and security screening capacity. Nationals from countries on that designated list are experiencing noticeably longer processing timelines for immigration benefit applications. This affects everything from adjustment of status to work permit renewals to travel documents. It is important to be precise here because this is where a lot of online content gets it wrong. These designations do not automatically mean denial. They mean additional review, longer timelines, and in some cases, a hold on final adjudication until that enhanced review is completed. There is a meaningful difference between a case being delayed and a case being denied, and that distinction matters enormously for how you approach your situation. If you are from a country that is currently under heightened scrutiny and you have an application pending, the most important thing you can do is stay in communication with a qualified immigration attorney, keep your documentation current, and avoid international travel without specific legal advice about your individual situation. Leaving the country while a case is pending can create complications that are very difficult to undo, particularly if your advance parole has not been approved. Now let's talk about immigrant visa processing, which is the pathway to a green card for people applying from outside the United States through a U.S. embassy or consulate. In January 2026, the U.S. State Department paused immigrant visa processing for nationals of a significant number of countries. The stated reason was a review of screening criteria related to public charge determinations. the process by which consular officers assess whether an applicant is likely to become financially dependent on the U.S. government. Non-immigrant visas, tourist visas, student visas, H-1B work visas are not suspended under that specific action, but immigrant visa applicants from affected countries who were in the middle of consular processing abroad have been experiencing delays, uncertainty, and in many cases, no clear timeline for when their interviews will be rescheduled. This is a painful situation for families who had been planning around immigration timelines. Someone who sold a home, ended a lease, arranged childcare, made career decisions, all based on a visa timeline they believed was solid, is now waiting with no announced end date. The practical advice from immigration attorneys is consistent. Do not make irreversible life decisions based on a visa timeline until the visa is in hand. Let's move to what is arguably the most visible new development in the immigration screening process, and that is the dramatic expansion of social media vetting. If you are applying for a U.S. visa in 2026, your online presence is now part of your application file. This started with students and exchange visitors on FM and J visas in mid-2025. It expanded to H-1B workers and their dependents at the end of 2025. And then, effective March 30th, 2026, the State Department expanded social media screening to more than a dozen additional visa categories, including fiancé visas, religious worker visas, and several other classifications that had not previously been subject to this kind of review. Here's what that actually means for you if you have an upcoming visa interview or application. When you complete Form DS-160, the standard online visa application, you are required to disclose every social media account you have used in the last 5 years, every platform, every username, including accounts you stopped using. This is not optional, and omitting an account is treated as a credibility issue, not a minor administrative error. Your profile should be set to public during the period your visa application is being processed. If a consular officer attempts to check a profile that is private or restricted, that can slow your case down. There are already reports of H-1B visa interviews being rescheduled and cases being placed into administrative processing, a category that sits between an interview and a final decision, specifically because of issues arising during the social media review phase. What consular officers are looking for is a combination of things: consistency between what you stated in your application and what appears in your public digital history, content that might be seen as hostile to U.S. institutions or aligned with designated organizations. The government has described the goal as identifying applicants whose intent or associations suggest they should not be admitted. The difficulty for applicants is that there is no precise published standard for what triggers concern. That ambiguity, combined with the broad discretion officers have, means that the safest approach is transparency and simplicity. Disclose everything, keep profiles clean and consistent, and do not try to game the process. There is one thing that catches people off guard with social media screening, and it is worth spending a moment on. It is not just what you post. Tagged photos, group memberships, and associations that appear on your profile, things that other people put there, not you, can also be visible to a reviewing officer. If a friend tagged you in something that creates a contradiction with information in your application, that becomes your problem, even though you did not post it. Reviewing your tagged content before your visa interview is now a genuine part of application preparation. Now let's talk about work authorization specifically, because this is affecting a very large number of people in ways they were not expecting. Employment authorization documents, EADs, commonly called work permits, now have shorter validity periods for many categories than they did previously. For applications filed after December 5, 2025, EADs for refugees, asylees, and individuals with pending asylum or adjustment of status cases are generally limited to 18 months. Some categories are limited to 1 year or less. This is a direct reduction from the longer validity periods that were previously standard. What this means practically is that you need to file your renewal significantly earlier than you might have planned. With processing times stretched across the board due to expanded vetting, filing the moment you are eligible, and ideally before that window if you can qualify for early filing, is the right approach. A gap in work authorization is not just an inconvenience. For someone on an employment-dependent visa status, a gap in their EAD can have consequences for their immigration status itself. There is also a critical administrative change that everyone applying for or renewing a work permit needs to know about right now. USCIS updated Form I-765 in early January 2026. After March 5, 2026, the agency only accepts the August 24, 2025 version of the form. If you submit the old version after that date, your application is rejected outright. Not reviewed, not held for correction, rejected. And a rejection means you lose your filing date and have to start over. For anyone on OPT or STEM OPT, where the timeline between filing and work authorization expiration is already tight, this is not a small administrative detail. It is a serious risk that has already affected applicants who did not know about the update. Check the USCIS website directly before you file anything, USCIS.gov, and confirm you are using the most current version of every form in your application package. Now let's talk about H-1B specifically, because the selection system itself has changed. Starting with the fiscal year 2027 cap season, USCIS is moving away from the purely random lottery system for selecting H-1B cap cases. A final rule published in December 2025 introduces a weighted selection framework that prioritizes higher skilled and higher compensated positions. Under the new system, selection rates vary based on the wage level of the position being offered. Higher wage positions will have meaningfully better odds than lower wage positions. What this means for employers and applicants is a shift in strategy. The competitive advantage in the H-1B lottery used to be largely about filing volume. Submitting multiple registrations was the dominant approach for some. Under the new framework, the quality and salary level of the job offer becomes central to the selection outcome. Immigration Counsel is advising employers to think carefully about how they structure their offers, how they document the skill requirements of the position, and whether premium processing makes sense for their timeline. For H-1B applicants who are already through the lottery and into the interview stage, social media screening is now part of your process as well. Reports from consulates indicate that H-1B and H-4 interviews are running longer and that administrative processing, the status where your case sits after the interview while additional review is completed, is being used more frequently than before. Planning for this added time is now a necessary part of the H-1B timeline for 2026. Let's talk about asylum specifically, because the picture there is particularly complex and many people are getting incomplete information. Asylum applications, Form I-589, have been subject to a pause on final adjudication as part of the broader review of immigration screening practices. The pause has been in effect since late 2025. Some holds have begun to be lifted for certain categories of applicants as enhanced vetting is completed, but the situation varies significantly depending on country of origin and individual case circumstances. Asylum applicants should not expect the timeline they may have read about online from a year or two ago to reflect what is happening today. The process is taking longer, the review is more intensive, and final decisions are being made more carefully than before. What remains consistent across all of this is the fundamental principle that asylum law exists for people with genuine protection needs, and those claims can still be filed and will still be adjudicated. The change is in the timeline and intensity of that adjudication, not in the legal availability of the protection itself. Now let's talk about what you actually need to do right now in 2026 to give yourself the best possible position in this environment. The single most important thing is to know your actual current status in the system. Log into your USCIS online account. Check your case status regularly. Use the official processing time tool at USCIS.gov. Not a third-party site, not a forum, not an anecdotal report from someone in a Facebook group. To understand where your specific form, in your specific category, at your specific service center, currently stands. The second thing is documentation discipline. In a system that is doing more thorough background checks, more identity verification, and more discretionary review, the quality of your documentation matters more than it did before. Inconsistencies between what you stated in one application and what you stated in another, between what appears in your file and what appears in your public records, are now more likely to be caught and more likely to slow your case down. Immigration attorneys are consistently advising applicants to do a thorough audit of their entire immigration history before filing anything new. The third thing, as we discussed, is your digital footprint. Before any visa interview, go through your complete social media presence. Disclose every account on your DS-160. Set profiles to public during processing. Review what is tagged on your accounts by other people. Make sure nothing visible online contradicts what you have put in your application. The fourth thing is timing on renewals. File early. Whatever the standard advice was before 2026 about when to start the renewal process for your work permit, your green card, or any other expiring document, move that timeline earlier. Processing times are running long, and the cost of a gap in authorization is significant enough that caution is the right approach. The fifth thing is travel awareness. If you have a pending case and you are thinking about traveling internationally, get specific legal advice before you book anything. The general risk environment for international travel while a case is pending has increased in 2026, particularly for applicants from countries under enhanced scrutiny. What used to be a routine trip abroad can now create complications that are serious and slow to resolve. And the sixth thing is legal counsel. This is not a situation where online resources or general information videos, including this one, are sufficient for making specific decisions about your case. The policies governing immigration in 2026 are moving quickly, being litigated in federal courts and interacting with individual circumstances in ways that require qualified, up-to-date professional assessment. An immigration attorney who is actively tracking these developments is not a luxury right now. For many people, it is genuinely the difference between a case that moves forward and one that stalls or goes wrong. Here's the honest summary of where things stand in 2026. The U.S. immigration system has not shut down. People are still getting green cards, still getting work permits, still getting visas approved. What has changed is the level of scrutiny applied to every case, the amount of time that scrutiny takes, and the degree of uncertainty that now accompanies applications that previously felt straightforward. The system is slower. The vetting is deeper. The requirements around social media, documentation, and form compliance are more exacting than before. And the people who are navigating this successfully are the ones who are informed, prepared, and working with professionals who know the current landscape. That is the reality of USCIS screening in 2026. Not panic, information, not speculation. What is actually confirmed and what you can actually do about it. If this video helped you, please share it with someone who is going through the immigration process right now. Leave your questions in the comments. We go through every single one. And subscribe so you do not miss our next update, because this is a situation that is continuing to develop and we will keep bringing you the latest.